Hello again, everyone. This is Merideth Nagel, and I want to thank you for joining us again for our latest edition of Homeschool for Realtors. Now, if you guys know anything about me, you know I love working with realtors. I love getting them out of trouble if I have to, but what I really love is helping them stay out of trouble. So in today's video, we're going to talk about the top 5 easiest things you can do to avoid the top 5 problems in a courtroom or before an ethics commission. Number 1, follow up text messages with an email. I get it. Text messages are an important part of your practice. They're an important part of my practice. They're necessary, but I want you to make sure that any substantive communications that happen via text message are followed up with an email. It's very easy to just send an email that says confirming our text. You keep that email in your file, and then if you later need it, we won't have the difficulty that we have with text messages of trying to retrieve them 2 or 3 or 4 years later, trying to get them admitted into evidence. Email is very easy to keep, very easy to enter into evidence. There's no reason you can't be doing this and avoid that problem. Number 2, if you represent a buyer, make sure that you take the responsibility of getting the HOA documents, meaning the CCRs, and the HOA financials, which you have a right to request and obtain, and pass those along to your buyer. Make sure that in that email where you pass them along, you tell them specifically that they need to read these documents carefully. And if they have any questions at all about what the terms and conditions of the covenants mean, or what any of the financial information that they are reading means, make sure that you refer them to the appropriate expert, either an attorney or a CPA. We have attorneys and CPAs that we can recommend that do this stuff at a very affordable price. Don't let trying to save your client money get you in trouble, because when they move in that association and they find out that there's a $25,000 assessment coming down the pike that they don't know about or didn't know about, but if someone had reviewed the financial information, they would have known about it, guess who they're going to blame? They're gonna blame the realtor. Number 3, make sure that you identify the source of information. One thing that often gets realtors in trouble is when they report information to their client without providing the source. So for example, if the building inspector gives you some information about the house that you want to pass on to your buyer, make sure you say, according to the building inspector. If a lender's representative says something, say, according to the lender. If the title company says something, say, according to the title company. You don't want to put yourself in a situation where you're vouching for this information that is not actually your source information. You probably can't even verify it. And your your client is going to justifiably assume that that information is coming from you if you don't already tell them that, in fact, it came from someone else. Number 4, don't be an expert. I know that many of you are extremely well versed in real estate law, extremely well versed in matters of accounting and as they apply to real estate. And there could be issues and questions that your seller or buyer might have that you think you have the right answer, and you might in fact even have the right answer. The problem is you might be wrong. And when you're wrong, it can go really, really bad. And again, who's going to be blamed? The realtor. It's a simple matter to refer them to a CPA to answer financial questions, attorney to answer legal questions. Again, we have people that are very affordable. Don't get yourself in trouble trying to save your client money and have it later ricochet back on you when your good act goes punished, right? And finally, number 5, avoid closing in escrow. I get it. There are many times when you have to close in escrow, but also there are many times when you're closing in escrow just because it's convenient. The problem is closing in with minor issues in escrow, say for example, escrowing $5,000 to replace an air conditioner. 90% of the time that's going to go very smoothly and there's not going to be any problem. But the 10% of the time when there's a problem, the problem could be major and often does result in expensive post-closing litigation. And again, who's the one who's blamed? The realtor. If you've got a client that's pushing to close an escrow simply because it's convenient for them, make sure, again, in writing, an email is fine, you advise them that, while generally these types of arrangements go fine, they can go bad. And when they go bad, it goes really bad. Because again, who are they going to blame? The realtor. So I hope that this information was helpful to you. As always, if you have any questions about any of the issues we've discussed or anything regarding real estate or your practice, go ahead and call me at 352-394-7408. I answer those questions for free for everyone, whether you close with my company or not, because I really just want to make sure that you are having the best practice and being the best realtors that you can be. So until the next time, happy listing and selling, and thanks again for watching.